welcome to the Real News Network. I'm Kim Brown in Baltimore. Earlier this month, 12 senators signed a letter to the chairman of the Federal Communications Commission questioning the use of stingrays by law enforcement. And in case you don't know what a stingray is, it is a cell phone site stimulator. And what it does is that it mimics cell phone towers, thereby allowing cell phones to communicate all kinds of information to it, such as location and other identifying data. The stingray can also capture the information of anyone in proximity of the person whomever is being tracked. And the senators expressed some concern that this technology is being overwhelmingly used in communities of color and asked the FCC Commissioner whether the use of stingrays are a violation of the Communications Act. And joining us to discuss this is Alan Butler. He is the senior counsel for the Electronic Privacy Information Center, or EPIC, and their organization tracks issues of the public interest related to the First Amendment and to constitutional issues of privacy. Alan, thank you so much for joining us.
Thanks for having me.
Alan, give us a little bit more background information of exactly what a stingray is and what its capabilities are.
Sure. So a stingray's device, commonly referred to as a cell site simulator, as you mentioned. It's a device that mimics the qualities of a cell phone tower, and by doing that, it basically forces nearby cell phones and devices to register or release identifying information. And so it essentially pings nearby phones and can gather a whole lot of data about those phones. It can gather identifying information. It can use these cell phone signals to triangulate the precise location of devices. It can also be used, depending on how it's configured, to actually intercept calls, to redirect calls, to block calls. It can really be used to do anything that a normal cell phone tower could do.
And the interesting thing about stingrays is that their capabilities are both precise and very broad. So the way that law enforcement agencies use them is to supposedly to be able to track suspects. But they're not just receiving the cell phone information of the particular suspect that they're trying to catch. They're also getting everyone's information who is in proximity of this individual.
That's right. There's really two supposed use cases of stingrays by law enforcement that we've seen them put forward in some cases, and one is to triangulate the precise location of a known device. So you have a device's identifying information, you think you know where it is, and you go to that place, you turn on the stingray, and it says, oh, the device is here. And then by measuring the strength of the signal in several locations, you can precisely triangulate within a few feet where that device is. And then the other use is to take essentially an unknown device and identify it by using a known location. So for example, if you're on the corner of two streets and you know that a suspect is there, you turn the stingray on and you see what devices are in the area. And then you go to another known location, and you know the suspect is there, you turn the stingray on, you see what devices are in that area, and then you cross-reference those lists of all the devices in those areas, and you see which device was in both places. So obviously in both cases, you're collecting a whole lot of data about all devices around you. In the second case, you really are combing through all that data and looking at all the people that were at a particular location. You might imagine another situation where you want to know everyone that was around a particular building at a particular time. It could be people at a bank, it could be people at a rally. And if you turn the device on, you can really capture all that identifying information.
That's incredible. And so the way that this is being used, according to the ACLU, there are 68 law enforcement agencies that are known to be using this technology. However, the actual number is not known because many agencies don't want to disclose the surveillance tools that are available to them. But we know that the Baltimore City Police have at least had use of the Stingray technology. They were admonished by the Maryland Court of Special Appeals, I believe it was March of 2016, for failing to secure a warrant in order to use the Stingray information. Can you tell us more about that?
Sure. So part of the reason that we don't know how many state and local agencies are using these devices is because what my organization, EPIC, found in a Freedom of Information Act lawsuit against the FBI several years ago is that the FBI, which provides training and access to these devices, was requiring state and local agencies to sign non-disclosure agreements in order to use them. And some of these state and local agencies believed that the non-disclosure agreements, that under the non-disclosure agreements, they should not inform the court that they were using these devices. So this happened in Florida. We've seen this happen in Baltimore as well. So the agencies basically are not telling the courts that oversee their activities that they're using these devices and that they're collecting all of this data about not only targets but also innocent persons. And so the court really is admonishing them for two things. For one, is not obtaining a warrant when they're locating a target in violation of the court's view of the Fourth Amendment rights of the target, but also in not informing the court that they were using this technology that sweeps up all this private data. So there really are two fundamental problems with the way these are used by state and locals.
One of the questions that the senators raised in their letter to Tom Wheeler, the commissioner of the FCC, was, does the Communications Act require that law enforcement agencies obtain licenses from the FCC to transmit over licensed spectrums, and does it refrain them from causing harmful interference? So that was one of the issues that they raised in their letter, was that partially, the use of stingrays or related technology could be interfering with people's ability to try to solicit emergency services.
Right. So the FCC, the Federal Communications Commission, regulates all radio communications in the country, and especially radio communications that operate on the same wavelengths as cell phones and telephone signals. So in order to operate a radio device like a Stingray, you have to have a license. Now, usually what happens with most consumer-end devices is the licenses are attached to the devices, so they're obtained by the companies. So in this case, the company that manufactures Stingray, Harris, would have to have FCC licenses. But in some cases, the users could have to have special licenses depending on how they use those devices. Now, the second problem you mentioned, the interference problem, goes to Section 333 of the Communications Act, which prohibits unlawful interference, willful interference with cell phone signals. This is sometimes referred to as jamming or blocking prohibition. And the problem with Stingrays is that they can block signals. So a Stingray, as I said, it acts like a fake cell phone tower. And when a device connects to a Stingray, that device is no longer at that moment connected to the phone network. So if at the moment when a Stingray is, connecting with your phone, you need to call 911, you may not be able to get out. You may not be able to reach an emergency number. And this has been a problem that the FCC has been vigorously enforcing in other contexts, prohibiting the use of jammers and blockers by not only bad actors but also state and local governments, because there are police agencies, sometimes private, sometimes prisons, for example in California, that have used cell phone jammers, and the FCC has been pretty stringent on the use of those technologies. So a similar claim here is brought against the use of Stingrays.
So it seems as if this technology being used by law enforcement is in a bit of an island on its own, where they may or may not go get a warrant to utilize this information against a specific target. And I mean, unless a lawsuit is brought, like there was here in Maryland, you may not even know whether or not your jurisdiction has this technology and is using it.
That's right. I mean, there's been a lot of grassroots work across the country over the last 5 years. As I mentioned, Epic went to the FBI to get information about that agency's use of these technologies and found thousands of pages of documents over the last 10 years outlining the agency's training of state and locals, interactions with agents across the country over the use of these devices. But people have had to go state by state and use open government laws and also comb through state budgets to find where these devices have been purchased, and use lawsuits and other methods to find out where they're being used. And again, part of the problem is that the courts don't even know when they're being used, because the agencies in most cases are not disclosing that they're using cell site simulators.
And lastly, Alan, I mean, the major concern, or at least the predominant concern that was raised by the senators, is that this technology is being used predominantly in communities of color. Has EPIC or any other organization that you're familiar with, have they found this to actually be the case?
Well, the senators are referring to a specific complaint that was lodged with the FCC by a group this summer. And there were a number of organizations that had done research in Baltimore specifically at the predominance of the use of stingrays. Baltimore has been held up as a particularly egregious example of state and locals, thousands and thousands of uses of these devices without warrants. And there's evidence in that complaint that this does predominantly impact communities of color. And there's a major concern, not only that this will be used in specific criminal investigations, but that it could be used during protests and other times where people are lawfully assembling, and essentially could create, lists of people there by gathering identifying information.
So, have you noticed that these law enforcement agencies have we noticed an uptick in trying to secure warrants in order to use this, or would we even know if that was happening or not happening?
Part of the problem is that warrants are not made public, and that's part of the process, really. Warrants are obtained what you call ex parte, which means that the government goes to a judge behind closed doors to obtain a warrant before they perform a search. So we don't get immediate statistics about how many warrants are being obtained. And part of the problem also is that there isn't a special Stingray or cell site simulator warrant at the moment. On the federal level, we have annual reports about the use of wiretaps, for example. And those are really useful. That's a really useful tool, because that way we can look back year to year historically and see how these authorities are being used. We need a similar provision for the use of stingrays on a state-by-state level. We really need a clear transparency law that requires these agencies to track the number of times they're using stingrays, to report the use, and basically to follow the lead of the federal wiretap reports in actually providing some transparency on how these devices are being used.
We've been speaking with Alan Butler. He is the Senior Counsel for the Electronic Privacy Information Center. They track issues of the public interest related to the First Amendment and constitutional issues of privacy. Alan, we certainly appreciate your time today. Thank you.
Thank you.
And thanks for checking out the Real News Network.